Try to hide behind the podium and Dave.
We're in charge for.
Well, we gotta behave, huh?
Yeah.
Please don't make this worth my life.
And,
Did you do that? Stop touching things, John.
All right, it's 6 o'clock. I will call this meeting of the Waushara County Planning and Zoning Committee to order. This meeting will begin with a public hearing. Anyone other than the applicant or their representative wishing to speak must register and submit the registration slip to the zoning administrator at this time. Following the hearing, we will conduct our monthly business meeting, at which time we will vote on the applications. You may stay and hear how the applications are decided, or you may leave following the hearing. The applicant and town board will be sent a copy of tonight's decisions. Any other person wishing to receive a copy of a decision can sign the sheet on the table at the front of the room. Those of you wishing immediate knowledge of the outcome of these proceedings may call the county zoning office tomorrow morning. The procedure we will follow for hearing each application is as follows. After each application is read, the applicant, their agent or representative will be asked to present their application, followed by any questions or comments from the committee. Then all correspondence will be read. Then others in favor will have a chance to speak. Anyone objecting will have a chance to speak. I will then ask for a summary of the committee's field observations and any staff comments. Finally, the applicant will be allowed a chance for a short rebuttal if they wish. Anyone wishing to speak should use the microphone. They should state their name and direct their comments to the committee. I ask that all testimony be kept brief, no more than 5 minutes, and to the point. If you are testifying as a nearby landowner, please tell us where your property is located relative to the subject property. Tonight's hearing will be recorded, and the recording will become part of the record. Comments that are based on hearsay or secondhand information, as well as slanderous or prejudicial remarks, will be ruled out of order. The committee has looked at all of the properties and the record will reflect these observations. Any person affected by an administrative decision of this committee has 10 days from the filing of tonight's decisions to make an appeal to circuit court. The county assumes no liability and makes no warranty as to the legality of any construction commenced prior to the expiration of this 10-day period. I will now introduce the committee. Bob Wadle, Bart Peterson, John Van Amerongen, myself, Dave Bossard, Todd Waller, the zoning administrator, and Becky Hubach is acting as secretary tonight. First issue that we have tonight to consider is a conditional use application. Nordic Mountain, Mount Morris, Wisconsin, has made an application for a conditional use in accordance with section 58-36411 of the Waushara County Zoning Code to construct a 32 by 75 foot two-story lodge with a walkout lower level to be used by employees and the public at Nordic Mountain in the OP Parks and Recreation Zone in the town of Mount Morris. Location, an approximate 200-acre parcel of land that is part of the northeast quarter of Willow Creek, west half northwest quarter, and southeast quarter of the northwest quarter. Now Lot 1 and outlots 1 and 2 of CSM 5842, Section 15, Township 19 North, Range 11 East, Town of Mount Morris, W5806, County Road W. Is the applicant present? Come on up.
I am William Reynoldus. I am part owner and general manager at Nordic Mountain. I'm not exactly sure what you guys, I know you guys have the application. You would have seen the plan so far. We're just looking to add an additional building for some much needed space that we have. The original building that was built in the 70s does not really fit our needs anymore. And we were hoping to expand with this new building that's very close to the existing building. There will be Some much needed office space, bathrooms, the ski patrol room will be moved over there. There'll be a very small place for eating. Ticketing will be through there. And a couple of other things, like a ski school locker room that we currently don't have. We could really use some space like that.
All right. So, if we've received your packet, there's a significant amount of information. You've got a good grading and erosion control plan in there. So I assume that you've had this surveyed
Correct.
sometime recently.
Yeah, it was surveyed. Last year.
And obviously you're far enough away from any property lines.
Correct. We're nowhere near any of the property lines.
Those are the questions that I have. Do any of the other committee members have questions for the applicant?
I do. I'm curious, do you have any plans for the old office space?
It'll still be office space. Currently, like most of our managers don't have an office. They kind of share a corner. Rick and I share an office that's the size of, probably that closet over there.
Yeah.
Maybe even smaller. You can hit your head everywhere you walk in the building. I have to walk around bent over most of the time, but yeah, the current building will stay there, so fully used. The ticketing area and the pro shop area will all be part of the rental building. So that'll just be the rental in that area, and then the office space above that'll still be used as office space.
Thank you.
Any other questions? All right, you may have a seat, and if necessary, you could come back up and give a rebuttal. Is there any correspondence?
We've received no correspondence and we have nobody registered to speak in favor, objecting, or informational.
All right. So staff comments.
Okay, everyone should have a final copy of the staff report. I'm just going to provide a quick summary. Nordic Mountain operates their ski hill business on a 331 acre tract of land, which is owned by Waushara County as part of Mount Morris Hills Park, which is a portion of the Waushara County Park system. It should be noted that the ski hill business at this location has been in business for over 40 years. The current leasing arrangement entered into in 2005 is not set to expire until 2030, with a possible 25-year extension upon renewal. Over the years, Nordic Mountain has undertaken several improvements and expansion to their facility. In 2000, Nordic Mountain received a conditional use to establish a 9-hole golf course, skating rink, tubing hill, and related facilities. In 2009, 2013, and 2021, our department has issued land use permits for various improvements throughout the grounds. Excuse me. Most recently, the applicant has approached the county and presented their future development plans at that time to the Public Works Committee on October 23rd. The committee at that time reviewed the plans and unanimously recommended that they go on to the Planning and Zoning Committee for a conditional use. Given the fact that development plans took a little time and that there's been since a restructuring of what is of the Public Works Committee, which is now the Facilities and Parks Management Committee, the plans were just recently presented to that committee on Thursday, January 16th. And once again, the committee felt that this was an ideal location and exceptional expansion to a very successful recreational facility. Staff's reviewed this request and applauds the success of Nordic Mountain and the regional reputation they've garnered. We believe that an expansion to an existing ski hill facility is an exceptional use of the land and ideal conditional use in a parks and recreation zone. While the committee will be making a recommendation on this request later in the evening, staff is recommending approval subject to the conditions listed in your report.
All right, thank you. Do you feel you need to make any rebuttal to that?
I don't believe so. It sounded good for me.
All right. With that, that's the end of the public hearing then. We will go into our business meeting. Becky, you have roll call? All right. Gentlemen, you've been provided a copy of the agenda. I will entertain a motion to approve the agenda.
Motion to approve.
By Bob,
I'll second.
second by Bart. Any discussion? All in favor? Aye. Any opposed? Gentlemen, you were given a copy of the minutes from yesterday's business meeting. I'll entertain a motion to approve those minutes.
So
Do we have a second?
I'll second.
Second by Bart. Any discussion, corrections? Hearing none. All in favor? Aye. Any opposed? Same sign. All right. No unfinished business? Moving on to new business action on public hearing applications. Gentlemen, you've heard the presentation for conditional use permit for Nordic Mountain, Mount Morris. Any decision on approval? I'll entertain a motion.
Motion to approve.
Motion by Mr. Waddle,
Second.
second by John. Any discussion, gentlemen? Do a roll call vote. Mr. Waddle.
Yes.
Actually, you should read the reasons.
Oh,
If you
yes,
could,
thank
sorry.
you.
Possible
Thank you.
reasons, sorry.
Yes,
And conditions.
yes, reasons and conditions. Bob, would you please read the approval conditions?
Sure.
Thank you.
The requested application, if approved, will be consistent with the spirit and intent of the zoning code and will not be contrary to the public interest because after reviewing the application and considering the testimony, which there wasn't any, the application, if approved with conditions, will not harm the public or neighboring land uses. The proposal matches the lot and available area, and that's it.
Thank you. Bart, would you read the approval conditions, please?
Sure. Therefore, the requested application, if approved, the following conditions shall apply. Development must be in substantial compliance with the site plan and testimony provided at the public hearing. All other required setbacks and all other codes must be complied with. All permits must be obtained, including land use, building, and sanitary. The applicant is responsible for meeting all applicable commercial building code requirements. Adequate parking must be provided. All drives shall meet all required codes, including fire and access code requirements to provide for access by emergency vehicles. The applicant will allow agents of Waushara County access to the property to ensure compliance with all applicable regulations. The development must be in substantial compliance with the site plan. The applicant is responsible for complying with any other applicable regulations, including any Wisconsin DNR or DATCAP licensing and codes, and shall operate the premises in accordance with those regulations and abide by all applicable safety rules. If any food is served, the Waushara County Environmental Health Specialist must be contacted for proper permits.
There you go.
Unverified.
If any alcohol is served, the township must be contacted for proper permits. And all advertising signs must be in accordance with all county and state requirements.
Thank you. We have a motion. We have a second. Now hearing the reasons and conditions, gentlemen, I will now ask for a roll call vote. Mr. Waddle.
Yes.
Mr. Ben Omgren,
Affirmative, yes.
Mr. Peterson,
I approve.
and I approve as well. Congratulations. Next on the agenda, review of possible action on extensions of land use permits.
We have none.
None. Review of minor change requests on previously approved public hearing applications.
We have none also.
Review of next month's public hearing applications for time and route planning purposes.
We do have two conditional uses at the present time. Three applications are and text amendments.
And text. All right. Then the zoning and administrator financial report was given yesterday at the business meeting. Therefore, we are to adjournment. Gentlemen, can I have a motion?
I'll make a motion to adjourn.
And a second?
Second.
Gentlemen, we are adjourned. Thank you.
Thank you.
Okay, here we go. Evening, everybody. We'll call this meeting of Osceola County Board of Adjustments to order. This meeting will be conducted in the same manner as the applications heard by the Planning and Zoning Committee. Please remember to keep your comments brief and relative to the matter at hand. Anyone other than the applicant or the representative wishing to speak at this hearing must have registered. Anyone who has not should do so immediately and submit the registration slip to the zoning administrator. The board has looked at all the properties and the record will reflect these observations. Following the public hearing, the board will conduct a monthly business meeting, at which time we will vote on the applications. You may stay and hear how the applications are decided, or you may leave following the public hearing. Any person affected by an administrative decision of this board has 30 days from the filing of tonight's decision to file an appeal. Such appeals are heard by the Waushara County Circuit Court. Information on appeals is available from the clerk of court's office and qualified legal counsel. The county assumes no liability and makes no warranty as to the legality of any construction commenced prior to the expiration of this 30-day period. And I want to introduce the board: Jess Irvin, George Peterman, John Shirk. I'm Kevin Fitzgerald, our zoning administrator, and our corporation counsel is here tonight with us. First matter, we have the variance tonight, tabled from the November 21st, 2024 meeting. Andrew Ananek, Madison, Wisconsin, has made an application for a variance after the fact in accordance with sections 58-235, sub 5, sub A, and 58-542, sub C, sub 2 of the Waushara County Zoning Code, exceeding maintenance and repair to construct a 12 by 12 addition onto a 30-foot by 40-foot non-conforming single-family dwelling, non-conforming due to existing home being less than half the required setback to the east lot line in the RS 20 residential zone within the shoreland area on Morris Lake. A parcel of land known as Lot 2 and 3 of the Morris Lake View subdivision, section 17, T19, T19N, R11E, Town of Mount Morris, fire number W6537 Simonson Lane. Will the applicant please step forward? Please state your name for the record and speak into the mic.
Andrew Rednick. I don't know if it matters, but I'm in Milwaukee, not Madison. So we had corrected that.
Okay. Tell us a little bit what you want to do and why you did what you did there.
In 2020, I had reached out to the zoning board to construct a walk path and a Three Seasons room off my house. I was told that because the right of way on a road, I was not able to do so. I've consulted with my attorney where, because the road has never been adopted by the town of Mount Morris, that the road was abandoned and the right of way. Even though the property that is built on the line, because of Wisconsin statute 80.32, that property is actually would be considered mine at that point. So it is my property butting up to my property because I am the one who maintains it in a private manner. The road is used as a private manner, not as a public manner. I did send an email. There's been a lot of correspondence prior to this. I don't know if that email was shared from yesterday, Mr. Waller.
Yes, everything's been shared with the board.
Okay, everything. And from our Monday meeting, I told you that I would bring the emails that were done in 2020. I have copies if people would like to see them. I have the original drawing that was presented with the Three Seasons room in the email. There's a couple sections that I have highlighted saying your drawing looks like what we talked about. Biggest question now is how close the existing house is to the right of way. Again, I believe the right of way has been abandoned. I believe we presented enough case law to show that it has been abandoned. And then we also removed a shed that we did not need to do to make sure that there was enough room for the impervious surface. And then furthermore, from Rick Erdl, I quote, "I'm still trying to work through some of the issues with your screen porch addition. We discussed the addition will be no closer to the ordinary high water mark and also no closer to the wetland. Our code does not specify a no closer than existing provision regarding wetland. However, it seems reasonable to allow that and the zoning director is on board with that. The rest of the email goes back to the discussions of the setback with the right of way. And I'm gonna have copies for people if they would like them.
Okay. Anything else? Okay, I got some questions for you. Has there been a recent survey?
Yes,
When was that?
a month ago, we submitted that.
Have you talked to the town regarding this?
Regarding what specifically?
When you built your addition,
No,
did you draw a permit to build that addition?
no, that would have been, somebody would be an active.
How will you deal with erosion and stormwater runoff? Did you deal with that?
I can implement any mitigating factors I believe we have, as we have a gutter system and it's pitched back towards the house.
What type of foundation did you put that addition on?
It is a cantilevered room, so it is on, I believe, I used the existing foundations that were used for the deck that was there that I deconstructed, and we added 3 more posts to help support the lower of the room.
How close is that addition to the wetland?
Mr. Waller estimated at 40 to 42 feet, but it is behind other structure, which is why in per the letter that it's not moving any closer to.
Are you sure of the wetland boundary?
I am not, we cannot run a, by the time it was, I guess, severely addressed, it is past the time to do the delineation report, as you can only do them for about 5 months out of the year. And I don't know if one was done after the drawdown of Lake Morris that had happened back in 2021. So I do not know if that had any effect on the recorded wetlands. Mr. Waller said he had one that he'd be up to sharing, but I don't.
There was a delineation, I can't even call it a delineation, but it was a Heartland landscapers were out at your next door neighbors because of an issue that they're having on their property. And per their delineation, their walkout delineation, I should say, said that we did a site visit very similar to yours and said that our estimation of the wetlands was accurate. So, and I'll talk about that.
What was the finished height of your addition that you put on?
I don't know, but it is less than the current roof line.
Did you meet the setbacks when you put that addition on?
Which setbacks are you referring to, sir?
Wetland setback?
Technically, no, from a 50-foot standard, going off the email saying that it's no closer than existing structure. I will note that the 50-foot standard that Washora imposes is double than what the state minimum is.
What is your hardship?
The way that my lot was construed, especially on lot 2, there's nothing to be built there. If I'm stuck with this wetland, we had put up a retaining wall that didn't know couldn't do. Agreed to take it down. I was told that is 22 feet from the wetland. That is more than half the distance of that parcel. That parcel is unable to be used. Where the latest edition of the house was done before I owned it was in '98. That edition moved it too close to the parcel line. So when I did a interior renovation of the property, which I pulled land use permits for, I was requested to combine the parcels, making them one parcel now. And I'm basically being told there's no way I can improve the value of my home.
Why did you need that addition?
I have 3 young children, and it'd be great for them to be able to be in a place where they're not having mosquitoes and bugs. It's really kind of for them, and it's a small house. We don't have, it's a walkout basement, but it's too short. I can't take the kids down there. My daughter gets up early, she's loud. I put her out there during the summer mornings and I sit out there so she can play and be a kid.
You got a permit for in 2020 when you were granted permission to put the walkway around. Why didn't you get a permit this time?
I did try to get the permit in 2020. and I didn't agree with the determination of the right of way. So I really don't have a comment on that.
Did you appeal that decision when they wouldn't grant you that building back in 2020?
Via email, I fought it. There's plenty you can see back and forth on there. I was a much younger man at that point, really didn't know the full appeal process, and having gone through all this, I don't think I would have at that time, knowing what the process is.
You understand that anything over $1,000, you have to draw a permit.
It is, the code reads $2,000 or that's I believe
150 square feet.
150 square feet. That room is 144 square feet. I misinterpreted that it had to be either value or size. Same thing with the retaining wall that I put it up. That's under 150 square feet. And that, since I did it myself, I mean, that cost was like $500. So I didn't think it met the standard of a structure on the retaining wall. Again, we'll take
It
that.
costs more than $2,000.
What does?
The addition.
The addition, yes, it costs more than 2,000. Again, I thought because it's under 150 square feet, it did not need it.
The proper way would have done this is to come and apply for a permit. And if you're denied, then you'd be here asking for a variance, not an after the fact. Is that correct?
That is correct. But at the time when I did go to apply for it, the right of way was also incorrectly applied to me.
But there's a proper procedure, the way to do things. You just can't decide on your own that you're not gonna get a permit.
So
You have to go through the protocol established by courts and the county laws. And it appears to me that at this time you haven't done it.
respectfully, there is a process, and also that process was mistakenly applied against me with that right away not actually being there. As you can see, as you go through the emails, that is the big point of contention, and that right of way has been abandoned and is a private road. The definition of a right of way is for the right of public passage, which does not exist on a private road. Had that been appropriately applied, I would have had the permit in 2020.
You know, when I asked you what a hardship was, and you said because you're a family, a growing family. And the Supreme Court has ruled that a larger family and it increased the value of your property or to enjoy lake living more. And this is from a case where they wanted to build a porch. And the court says that that's not permissible.
I believe I did not state that the hardship was that I have a growing family. You asked why I did it and I have a growing family. The hardship is that I have two lots. Had those two lots been separated and I wanted to build on lot number 2, I would not be able to do so. The fact that I added a small room onto my house, I think is reasonable, and it's even stated so by the zoning board.
So everything I've seen and looked at, that you build closer to the wetland. And on Mr. Ertl's paperwork that I have a copy of, when he was out there on 7/22/20 discussed allowing 25-foot expansion no closer to the wetland than existing. And you're closer now with the addition you put on?
That is not correct. Stairs are considered a structure. There is structure for the walk path. The Three Seasons room is behind the stairs, therefore not any closer to the wetland. Plus, the room is set back multiple feet from the house, and the house is in the wetland. State of Wisconsin under NR 115 allows an expansion for the house as long as it is lateral movement, and it is a lateral backwards movement.
If I could, I just want to refer, I'm going to go back to the wetland maps per the surface water and drainage mapping per DNR plus our mapping. The 12-foot expansion that it funnels down and actually the wetland starts in your yard and actually kind of converges outward and goes towards your neighbor's yard and then considerably onward from there. Based upon the mapping, your existing house is 39 to 40 feet, the existing corner of the house. Even with that 12-foot, that reduces, it goes down to 36 foot at that point, and that's based upon the DNR maps. And which we have adopted as part of NR 115 and part of our shoreland code. So you actually are encroaching further into the wetlands. And that's something that was discussed with you back in 2020.
As I said, the walk path that was approved.
I'm talking about the corner of the structure, not the addition, or not the stairs, the actual corner of the addition.
Yes, the stairs are at the same length as that house. And as a structure, it would have to hit the stairs first.
I don't have any more questions, Jess? George,
I do have one.
speak into the mic, please, George.
I do have one question. So I know in our staff report, it says that, the owner, is making, a request, for variance. But from just talking to you the other day, the information that we received, is your actual request that you don't even need a variance, or are you are you sort of conceding that you do need a variance and you're requesting one?
Had this, the primary argument, this entire time was for the right of way of the private road. Had that still maintained the argument, I would argue I do not need a variance. I should only have to do a after the fact building permit. The right of way, or not the right of way, the wetland has been re-raised as an issue where even though the picture was provided, shown where the room was going to be and told that is reasonable and that the zoning director could sign off on that. Now that's saying that if that is the what is making my house non-conforming, that is where I would say, okay, fine, I need a variance. And again, under NR 115, the lateral movement is allowable to expand a non-conforming structure. And
For the record, that's for a shoreland setback, not a wetland setback. That's NR 115. That's you're allowed a 200-foot lateral expansion. However, with that 200-foot lateral expansion per our shoreland code, you would also owe what is called mitigation. And the mitigation would result in additional vegetation up near the water. So you're kind of mixing a couple codes here, the ordinary high water setback and the shoreland setback or wetland setback.
When I was searching for wetland codes, that's where it was popping up. But
Just the DNR doesn't have a setback requirement for the record. It's the county does.
Okay.
So just to be certain, you're in agreement that you do need an after effect variance?
Due to the wetlands, yes.
Anything else, George?
That's it for me.
John? Looks like you have a question.
Just following up on what George said, so you're applying for a variance for the setback, but your addition to your screened-in porch or whatever, you did not get a building permit for that.
Correct, I would have to pull an after the fact building permit.
So you have not applied for a variance for that. Is that right?
Correct. Well, that's, I believe that's what this is with us.
I'm confused on what we're discussing.
This after the fact variance would allow me to pull the after the fact building permit if my understanding is correct.
Okay.
You're asking for a variance that we've never granted a variance for, to go closer to a wetland.
Just because it hasn't been granted doesn't mean it can't.
We denied
I understand that it's been denied. And again, from a definitional structure code, there is structure in front that was approved. This is not moving closer than that structure.
Excuse me, the structure you're referring to is this part of the stairs, excuse me, and the walkway. We do allow walkways per code to encroach 5 foot, up to 5 foot within any applicable setback. So that is not the issue, it's the actual structure itself and the footprint of that structure. That's, we keep on going back and forth to the stairs. Stairs and walkways up to 5 foot in width are permitted within required setbacks. So that's, it's the structure itself, though, that's where I keep on going back to. Your existing structure, the existing house is set back at 39 to 40 feet.
Yeah.
12 foot out, you have another little corner of your addition. That is 36 feet back from an existing wetland, thereby encroaching into the wetlands, increasing the degree of nonconformity.
You did state that it's increasing into the wetlands. It's not increasing into the wetlands. It's increasing into the wetlands setback.
Correct.
Yeah.
Correct.
But there is a.
And I apologize.
there's a-
You're correct. It's into the setback.
It is also a setback that is twice the length of what the state needs. I understand that it hasn't been done. I do believe there's enough mitigation that is either currently done or I can also do. And again, this is a room that has moved backwards. Have it in email for referral. He's reviewed. The photo will show that it does go 12 feet out, just like the house is, and that quote seems reasonable to allow that, and the zoning director is on board with that.
And if I could, I'm in defense of Rick Ertl. He's a technician that's out in the field reviewing plans that are not detailed. Nothing was laid out, nothing has been platted out. And so you're looking at, having a technician out in the field make a judgment call. And yes, you're correct. If it was lateral and was not approaching further into the wetland, we wouldn't even be discussing it. But the fact of the matter is that wetland actually balloons out as it goes further eastward from your property. Your building juts out 12 more feet, thereby you're actually encroaching further into our wetland setback. That's, and once again, for Rick out in the field to make that judgment call, he did make he did make the statement in his it was July 24th, 2020 email to you saying that you can go no closer to the ordinary high and also no closer to the wetland. That was a statement that he had made to you in an email. And yes, if you maintained that setback, we wouldn't be discussing it. But the fact of the matter is you actually are encroaching into that setback. And I know Ruth wants to discuss the right-of-way issue, and that's another issue in itself.
Okay.
I have another question. Did you have reasonable use of your house before you added this addition on?
What do you mean reasonable use?
Could you use it, use the lake, enjoy it, stay overnight? I'm having trouble understanding. You came for a permit, you got a permit, put the walkway and the stairs. At what point? And I mean, we looked at it the other day, the footings for the stairwell are there, the wood's all there that you removed probably from where the walk and the stairs were. At what point did you decide that you were gonna add that room?
Several years later.
Hmm?
It was several years later once I had kids.
Anything? No, anybody else? We're good. Please have a seat and then we'll give you a rebuttal. Where are we going?
Do you want to just go to
Yeah,
correspondence?
correspondence?
We've received no correspondence and we have nobody registered to speak in favor, objecting, or even informational. I know Ruth Zowski, our corporation counsel's here, and I believe that one of the issues we probably should discuss is the right of way. and whether or not the statements from the applicant are accurate regarding the vacation, excuse me, and then the balance of the property being turned over to the resident.
The chair will recognize the corporation counsel.
Evening, everybody.
Good evening, Rudy.
Mr. Waller shared with me the emails that the applicant provided with information and case law from his attorney Giles. He had cited 2 different cases, and apparently you people are not moving enough.
Yeah.
It's hard to say.
There we go.
I just want to address the cases that Attorney Giles had sent to you through his emails from the applicant. The first case that he sent is the Gogolewski case, Gogolewski. And that case talks about the need for a township to make an affirmative action in order to make a platted road public. I will tell you that I do believe that the applicant and his attorney are correct that that case is applicable in this matter. The plat that was done in this matter was done in, I believe Todd told me 1948. Gogolewski is a Supreme Court decision that applies, well, it's a court decision that applies to lands that were platted prior to 1951. So if the plat had been done after 1951, the statute changed at that point in time, and in Van de Sandy versus the town of Marquette, the court then said that as to the affirmative action needed to be taken by the town to actually make it a public road, that part of Gogolewski is then reversed. So if this plat had happened in 1951 or later, we wouldn't be talking about this. But it happened in 1948, so I do believe that Gogolewski does apply to this matter. And so in that matter, what it says is that if the township did not take an affirmative action to accept that road, it remains a private road. So we don't have any information that says that anytime the town of Mount Morris had an affirmative action to make that. So I agree, it's a private road. And so the question then becomes, well, what does that mean as far as setbacks, right? So you're not looking at a setback to a public road right away, right? Because it's not a public road. But does that mean that there is no setbacks? Well, part of the argument from Attorney Giles is that we have this plat from 1948, and we need to use that plat as evidence that this is a private road. Well, on that plat itself, there are setback conditions written. So I don't think that you get to pick and choose which parts of the plat you want the board to recognize and which parts you don't want to. If the plat is in and that's what's controlling, then the plat is in and that's what's controlling. And so the plat itself has a setback for this area, which is 10 feet, I believe, on the plat. Was that what it was? So that's different than the private, that's than the road right away setback, right? Okay, so even if you then forget about what's in the plat, although I think the plat is controlling, if we're saying that the plat controls that it's private, that doesn't necessarily mean that there's no setback, right? Maybe there's no setback to a road right away. But under no circumstances is a property owner able to build all the way to their lot line, right? Because then you would have property owners building lot line to lot line, you'd have structures butting right up against each other. So there's always some sort of setback. It's just what is the setback that is appropriate, right? So maybe it's not the public road right away, but there's probably a setback. I'm gonna argue that I think that it's the setback that's in the plat because we're using the plat to determine it's. The other case that he sent, was the KGR case, and that case, has been reversed. It was, sent, the Supreme Court, did not agree with the Court of Appeals. They sent it back to the Court of Appeals. They did an unpublished decision, but the portion that was being relied on, was the part that the Supreme Court reversed. So I don't think that that case applies at all in this matter. But that's where the case law that they have provided falls, in my opinion. So I do think it's a private road. I don't think you're looking at a public road right away. But I don't think that that means that there's no setback. And in my opinion, the setback that applies is the setback that's in the plat that we're relying on.
Ms. Salsky, I have a question for you. Andrew had made a comment that because it's been reverted over to private and no longer public, that the land itself has been reverted over to their ownership. And I'm not aware of any vacation order or anything like that, nor is the town chairman, because I did talk to Dan Novak about this. But if it did go private, that right of way or easement way would still exist, correct?
Potentially, I think that that's probably something that would have to be determined by a court. If it has always been viewed and used as private without any objection and it's known, it could potentially be back to private land. I don't know how the town is assessing that land. I don't know that this decision is based on whether that's private land or not private land, or a right of way. I think that the plat itself gives you a setback, and that's what we're using to determine that it's private, right? Because it happened prior to 1951. I know now, right, there has to be a court order to vacate. But prior to 1951, the town had to do a affirmative step to make it public. So because they didn't do that affirmative step, it never became public. What does that mean? I don't know what that means. I think that's something that would have to be sorted out. But I think that you also then look at the plat itself that has its own setback in it, and then you use that.
Sowski. Isn't there like an affirmative acceptance of this plat as written, notarized right on the plat?
No. And you would think so, right? But so if in the Gogolowski case, the court had determined that the mere fact that the town signed off on a plat as part of its ministerial duties when a plat was submitted was not actually accepting the dedication to a public road. It was agreeing that the plat met the requirements for a plat. So it was approving that. I think that that is probably why in 1951, the law changed and said, no, if the town is approving the plat, that's their affirmative action. But that didn't happen until 1951 when the statute changed. And that was the distinction that the court made then in later cases, saying that there's a difference between plats pre-1951 and after 1951, because the language in the statute about the town's responsibilities in approving plats and the way to vacate things dedicated on plats all changed in that time. So if that exact plat had been done after 1951, you would be correct. But because it wasn't, the law back there prior to 1951 did not recognize that, according to our courts and law that we have to follow, as an affirmative action.
Okay, it just seems funny because it says that we adopt from the owners in the subdivision signed and then certified resolution adopted by the town board of the town of Mount Morris.
You know, I guess if I could see the resolution, right? the resolution could be an affirmative act, because the court in Gugalowski talks about the town adopting a resolution or something as an affirmative act to the road. Now, so to accept the road dedication. So if that resolution in 1948 stated that they're approving the plat and accepting the road dedication, then yes, it would be public unless it had been vacated. But I don't know what that resolution states. But the face of the plat itself is not an affirmative action.
Okay. Thank you.
Ruth, back to the private road.
Yeah.
If we're saying that this is a private road, is he owned to the middle of the road?
Most likely, I don't know what it's being assessed at.
So every property owner owns to the middle of the road. Do they have to get permission from other people across the property to get to their property down the road?
I don't know.
I mean, because we have utilities that go down there.
Yep.
The propane truck comes in and fills the tanks, the phone lines are.
But it's my understanding that this particular road that we're talking about is not used for vehicular traffic from the public, that they access the properties from an actual different road. So, and there could be other covenants or something in the area about how the landowners are going to maintain the private road. It could just be that it has just been left to be overgrown and it's just considered private property. I don't know, and I think that that's like, I think that's really something that I don't know that we need to get hung up on, right? Because if we're gonna agree that it's a private road because the plat was, because the road dedication was not affirmatively accepted by the town back in 1948, and the Supreme Court says this makes it a private road because there was no affirmative, this makes it private because there was no affirmative action. We're relying on this plat, right? The plat itself has setbacks in it. So why don't those setbacks apply then? If the rest of the plat you want us to rely on, you can't pick and choose which parts we rely on. The plat is either in or it's not.
That's all I have. Anybody else?
Is there any benefit to going to the town of Mount Morris and asking for their record of that resolution? Is there any need?
For your purposes, I don't know that there's a need, right? So if the argument is like, do I need a variance from the setback? The question is, what is the setback, right? So there's a setback in the plat itself.
That's not gonna change regardless.
And that's not gonna change. I mean, if it became a public road, then there's a setback in the zoning code from the public road, right? And my understanding is that the setback from the public road is less than the setback in the plat. Right? Or,
It actually, the setback that's on the plat is only 10 foot. We would have applied a 15-foot setback. But the problem here is that the home, based upon the plat of survey that was submitted by Trent Nelson, the house actually encroaches into, so it's actually over the property line. There's no setback at all. Making the house non-conforming, existing non-conforming.
but I don't know if you need the town's stuff to figure out the setback. I think that there is a setback. I think you need a variance from the setback. Certainly, it would be interesting to know what it was, and you know, if this goes further, it might be worthwhile to have that and know exactly what we're talking about, but.
And I was more thinking down the road, if this comes up again, you know, with another house on the same road or a similar situation in a different township, that now we're not sort of going through all the trouble that everybody's going through, you know.
I think that if a similar situation comes up on a plat that is pre-1951, yes, we should try to get as much information we can about what actions the town took so that we know what we're dealing with. In some cases, you're gonna know, right? Because the road has been improved, it's being maintained by the town, it's you know, so those ones you might not need that, right? In a situation like this where it doesn't appear to be improved, the town doesn't appear to be maintaining it, you might want to have some more information before you're able to give landowners correct direction on what applies.
Best information taken away from all this is 1951s are cut off, so.
Yes.
Yeah. All right, perfect.
Thank you, Ruth. Staff comments.
Okay, everyone should have a copy of the final staff report. It's rather lengthy. I'm not gonna get into, reading it verbatim. But we basically have three issues here. We have an existing non-conforming house based upon a right-of-way setback or property line setback. In this instance, there is actually no setback that's being provided. And our code does allow provisions that if you're less than half, you get a 25% expansion, greater than half. And that to the setback, you get a 25% expansion, anything less than half. And in this instance, nothing, if your house is limited to repair and replacement. We also have an existing non-conforming house based upon the wetland setback. The existing house is setback only 39 to 40 feet, when a minimum setback of 50 foot is required by code. And then lastly, we've got illegal construction of an addition being built without permits, the land use permits and building permits. I do have a stack of emails that I've made part of the record that go back all the way to 2020 to present. This was specifically discussed back in 2020 when they originally appeared before the county, and Rick on his onsite. Rick had told them that the likelihood of getting a variance is very slim based upon the right-of-way setback. The issue with regard to the wetland was stated purely if you can maintain the setback and not encroach upon it and not increase the degree of nonconformity, we'd be okay with it. Obviously, the encroachment into the wetland is there. This was discussed in 2020. As a result, the applicant had revised his plans from that of an addition and a deck to a 5-foot walkway around the house. I have a land use permit that was issued in 2020 for that. Now, we have granted variances. This board has reviewed. We've granted variances to existing non-conforming houses that are limited to repair and replacement. We've granted variances to houses that do not meet, existing houses that do not meet the wetland setback. However, it's always been the direction of this board that if you're going to build an addition, the addition should not increase the degree of nonconformity and should be built such that it meets all other applicable setbacks. That isn't applicable in this situation. And now, once again, the staff believes that the applicants were informed of all of this back in 2020. And I think they rolled the dice, so to speak, to see whether or not this would get caught. It took almost, a couple of years and that for this ultimately to be found by Tom Barker, our, technician that was out in the field. And we just believe that while the, board will be making a recommendation on this later in the evening, staff is recommending denial because this would set a very dangerous precedent, allowing an addition to encroach upon an existing wetland. And with that, we also, for the denial recommendation from staff, is that the applicant should be required to remove the 12x12 addition by June 1st and replace the elevated walkway that was approved under land use permit 2324. And that also the non-conforming retaining wall that was recently constructed without permit should also be removed by June 1st of 2025. And that the property be regraded back to the original elevation and reseeded to match existing.
Thank you, Todd. Any questions of Todd? John? Jess? No questions. Thank you. Rebuttal for.
Come up. My, the Wisconsin State statute 80.32 is what would establish property line to the original owner's property subject to an access easement for the questions on who owns the property of that private road. I maintain that with that right of way had this been properly looked at, when I applied for that, there could have been a further conversation of, well, you just have to move it 3 feet towards the east. And that could have been done, but because the right of way was being incorrectly applied to me, I wasn't able to get that in 2020. And the addition of unconforming, the house was added onto in 98, which would be expanding the non-conforming. So there is a precedent that has already been set with that.
The wetland setback didn't come into play until 2004 here at the county.
You were referring to the right of way before, that it was non-conforming, was legal but non-conforming, and the house was still added onto by almost 440 square feet.
Because back then, and I've reviewed all the minutes from that, and our staff was not aware of or not familiar with exactly where the setback lines were. If you recall, you did also have a setback line due to the side lot line, and that became an issue later on as part of your interior work, which we asked for you to consolidate the lots by way of a combining lot affidavit. But that was brought up, and we had also asked you for a plat of survey back then. Nothing was ever furnished.
When you can find the 2 outside points, I believe you don't have to provide a survey. And I was asking for.
We had asked for a survey to identify exactly where exactly the house was. And that by combining the lots, it was assumed that, you know, now you more than met your side yard setback, because at the time, the addition was actually encroaching upon the side yard setback.
Correct. And I think that same principle is applied here, that it does not need to meet a 10-foot setback if I also own the land of the private property. It could be mitigated by, again, combining lots. It was done once before, and it could be done again.
That combining lot affidavit had to do with the side yard setback, not the front yard setback. That's the combining lot affidavit was merging lots 2 and 3 of Morris Lakeview subdivision, combining those 2 lots.
That I understand. The code also does not specify a front yard setback. I get that a 15-yard setback has been, or a 15-foot
Your
setback.
plat refers to a rear yard setback in this instance, 10 feet, and that's what we were talking about earlier.
On the original plot.
On your original plat.
And that's where it was already infringed upon once with the side yard setback. I don't see the degree of difference between the front yard to my plot now. If they could be combined, if lot 2 and 3 could be combined, I don't know why the front yard couldn't also be combined to mitigate that.
Another lot?
That's statute 80.32 says that I own it.
Oh, I'm sorry, you're talking about that part. Okay.
So again, I understand that a variance of this has not been done. You again had said that I'm encroaching into the wetland. It's an encroachment into the wetland setback.
Into the wetland setback.
Yep. As you know, there hasn't been a new delineation report, especially after the drawdown that happened in 2021. Guys walking the property, I don't think can accurately determine that. And it's too late. It's not in the season to be able to do a delineation report. Had this right away been solved, I think it could very easily done in 2020 to say, all right, the measurements could have happened to say this needs to just be 3 feet more, and then a variance could have been granted based on that.
You're putting a burden on the county. If you would have got a permit, this could have been hashed out at that time when you applied for a variance to put that addition on.
I did apply for the permit, and again, the right of way was being incorrectly applied to me.
If you would have been denied, or you could have been told at that time if you applied for a permit to get the map, the wetland map. Right? And then you would know for sure. But you took it upon yourself to build without permission.
I did, and the county also incorrectly applied that to me, which was a measure that happened first.
That's your opinion.
I'm lying, it's factual.
Were you ever told by any of the county staff that you do not need a variance for any of the work that you're doing?
It was not specified that I need a variance for the wetland. It was specified that I need a variance for the right of way. Which again has been, in my opinion, abandoned. And.
This was after the fact, after you got caught,
Doesn't change the fact.
right? That you needed you needed a variance after the fact. But before that, nobody said you didn't need a variance to add that on.
I was told I needed a variance because of the right of way. And I'm saying if you go back to 2020, that would be incorrect based on that right of way not actually being there and being incorrectly applied to me.
But there was never a variance request made to be able to hash that out at that time though either.
Because I was told it would be denied because it's 7.5 feet from the right of way, a right of way that does not exist. This is the information that was being provided to me by the county that turned out to be incorrect.
But you didn't challenge that.
I have incurred a couple $1,000s in lawyer fees to find this out. You guys have counsel as well. It is for my lawyer is on the board and the council to have this in place and know this based on this rule. As she said, she's learned this. It should have been something that was known prior.
She also said that the plat map shows a setback requirement that you do not meet, whether this is deemed private or public.
And it also didn't meet side yard setbacks, but I was still granted a land use permit in that as well. And again, there's
Those decisions aren't made unless that request is brought in front of this board for a variance though. You can't take that upon yourself to make that decision. You understand that?
I did not make the decision of the side yard setback. I was told I just had to combine the lots. And so therefore I did. I was not instructed to do the walkway to come before this board. I was just told to combine my lots. I was not given an option on that. Actually, I think that was for my land use permit to do the interior remodeling of my home, not even for the walkway.
So you took out permits for all this stuff, but you never took out permits for this addition.
Correct.
That's all I have. Do you have anything else?
Again, I could have had this right away not been applied to me in 2020. There would not have been the discussion of the 7.5 foot setback. And with the knowledge of that property in front of me would have been mine. I don't even think at the time I would have required a variance based on the email conversations that we had. Obviously that's now being brought up by the wetlands, the 10-foot rule. I think it would be the same applicability of the side yards being combined. There should be no reason that front yard and the current lot can't be combined or parcel A in the plot of survey. And had that been appropriately put to me, we could have easily moved this room 3 feet towards the east.
Any question? We'll conclude this public hearing. We'll go to our second public hearing. John and Sherry Bell, DeForest, Wisconsin, has made an application for a variance in accordance with section 58-542 sub C sub 2 of the Washington County zoning code to construct a 2-bedroom, 24-foot by 36-foot single-family dwelling with an 8-foot by 24-foot attached deck to come within 11 feet of the east lot line and 11.23 feet of the west lot line, 15 feet required, located in RS 20 single-family residential zone within the shoreland area on Witters Lake. A parcel of land known as Lot 20, Block 2 of the Witters Lake Clearwater subdivision, Section 15, T18M, R10E, Town of Dakota, fire number W8427 Clearwater Avenue. Will the applicant and his representative please come forward? Please state your name for the record.
John Dix, Los Alamos, Oklahoma, builder
Thank you.
from the Bells.
Go ahead. Just tell us what you want to do there.
Pretty much, standard size lot, 48 feet at the lake. 55 feet of the road. Encroachment, 4 feet on each side, about 24 over my house, just kind of difficult. Anything much smaller than that on that lot. So that's the reason why they requested this variance.
The information we got everything, and I'm gonna ask you, has there been a recent survey?
Yes,
We know where the lot lines are. The
yes.
neighbors in town know about this?
I'm not sure unless they're notified by the county.
What type of foundation you're gonna have?
4 foot frost wall,
How far above the existing grade will the first floor elevation be? And how much filling and grading will be done?
Bill will have to be hauled out. Reading will probably be up to about 12 inches below the where the vinyl siding meets the foundation wall. 12 inches.
Okay, finish height? Finished height of the building?
I'm sorry?
Finished height of the building.
It'll be under 30 feet,
What was it?
under 30 feet.
Thank you. Erosion and stormwater runoff, how are we gonna deal with that?
Absolutely. Little silt fence all the way around 3 sides of the property.
Any other improvements planned?
Only what's on the record here is requesting this 10 by 10 existing shed right now. They want to remove that and replace a new one in the same footprint.
Is there a holding tank there?
Yes,
Is that by where the shed is?
very close, yes.
Do we have any non-conforming structures on the property?
No,
What are the
oh, I'm
options?
sorry, excuse me. Yes, there's existing dwelling right now that would be removed. In place would be the new home, so yes, that's,
You'll be farther away from the lot line with the new house, right?
we will be, yes.
Um. What other options do they have there besides what you've planned?
It's pretty much a postage stamp lot that was sufficient when they made the plat, maybe 1950s, things like that. And today the people are just building larger homes than they have in the past. And so this home, 24 by 36, is 864 square feet.
How many square feet you know?
864.
What are the hardships and unique property limitations which support this request?
As I stated earlier, due to the width and depth of the lot, the building footprint of the home would not meet current setbacks as established by the local zoning codes. Unique limitations at the time of the initial development of Warriors Lake lots, the cottages that were built on the original plat were smaller in contrast to the current zoning requirements for larger lots. Current building setback codes have a negative impact on being able to build a home on a lot of that size. As far as protection of the public interest, the request for the variance is not burdensome to the public interest. The request to build a home for the attached footprint is reasonable to request the current setbacks to be relaxed.
Thank you. Permits, you know which ones you'll need, correct?
Yes.
If this was approved, when would they start? Frost is out of the ground.
No, we break ground year round. So it probably be within 30 days or so.
That's all I have. Any questions from the committee? Oh, John, where's the well?
There will be a new well. It'll be between the shoreline of the lake and in the house.
Is it gonna be drilled or a sand point?
That'll be drilled.
That's all I have.
Can't have a sand point.
Gonna be drilled, he said.
Thank you, Pat. You got anything, Jess? No? Okay.
Thank you.
Have a seat. We'll give you a result if you need it.
Appreciate it.
Correspondence?
So I have a letter from Tom Konopasek I see he's online. Tom, would you like to speak?
Would you like to speak?
Yes, I would.
You have the table.
Go ahead, sir.
Go ahead.
Okay, thank you very much. I am directly across this road from the parcel we're talking about. The address of our house is W8428 Nakoma Avenue. And I have been up there for over 50 years. And my concern about this new construction, tear down and new construction is this. How are my viewpoints going to be changed because of variances to the east and to the west, especially on I think it's on the west side where this porch is supposed to be constructed.
Tom, if I could, right now, the existing two-story house is approximately 30 feet in width. The house that's being proposed is 24 feet in width, so it's actually going to be narrower. And, you know, when you also incorporate, you know, your gable roof, it's going to take up less of your view than what you see presently, because right now you're looking at more or less the side of the two-story house.
Okay. I understand what you're saying. And now, when it comes down to, will there be any more, I'll say, construction done? I guess I'm concerned about a garage and other things that could interfere with my family's view.
I don't believe they have room just based upon where the holding tank is going to be situated, where their sidewalk is, and then the fence right next door. They're going to be very limited in space. I really don't feel, and I'm looking here at the averages from our onsite, I really don't believe that they're going to have adequate room in which to place any accessory structures.
Okay, fine. You know, I think you have answered my questions to my concerns, and I appreciate your time.
Thank you.
Thank you, Tom.
Thank you.
Yes, thank you.
I also just would like to make note that Don and Susan Lith Johannan called. They're at W8410 Clearwater Avenue. They called on 217 just to state that they're in favor of the request.
Thank you on that. Any objections?
I have nobody registered to speak.
Staff comments?
Okay, once again, everyone should have a copy of the final staff report. Outside of an original sanitary permit that was issued in 1995, county maintains very little information on the original property. We did conduct an on-site back in November of 2023 to measure all setbacks to determine averages for a possible raise and rebuild. At that time, we did tell the owners that should they choose a raise and rebuild, that they would have to require or provide us with the updated survey, and that given the narrowness of the lot, that most likely a variance would be required. The lot itself is a very narrow lot, averaging just over 47 feet, which dates back to 1928 when it was part of the original Clearwater subdivision. As illustrated in the plat, the owners are now raising an older two-story non-conforming house that sits just a couple of feet off the west lot line. And they're erecting a new two-story bedroom in its place that will be centrally located upon the property. It also just note that the home will meet the average setback of 37 foot for an open deck, 43 feet for the principal structure to the ordinary high, and that it'll also meet the average setback of 36.5 feet to the road. Now, based upon some other things per the narrative, the owners are also talking about removing an existing sidewalk, replacing an existing shed, reducing the overall impervious surface on the lot. It's modest, but from 21% to 20.26%. And also the owners will be submitting a sanitary reconnect permit as they wish to reuse their existing 2,000 gallon concrete holding tank located at the northeast corner of the property. Just for the record, the county records in terms of maintenance show that that has been routinely pumped and found to be in satisfactory working condition since its original installation in 1995. Now, the board visited the property at the recent onsite on Monday, February 17th, excuse me, and were generally supportive of the variance request. The board felt that the request was in line with very similar variances granted in recent year and that the home was in keeping with the size of the lot. Given the fact the existing non-conforming home is going to be raised and the new home will now provide somewhat reasonable side yards on both side lot lines, as well as meet the required averages to both the roadway and the lake, the board felt that this variance request made a bad situation better. Staff's reviewed this request and we concur with those comments made by the board. We also believe that the owner has gone to great lengths in an attempt to address staff's concerns. A home being only 24 feet in width, which is 2 feet smaller than mine, is a very modest house, especially by today's standards. While the board will be making a recommendation on this request later in the evening, staff is recommending approval of the variance as listed, subject to the conditions listed in your report.
Questions of Todd, anybody? Jess? George, John?
No.
I have no questions. Thank you. Any rebuttal needed, John? Thank you for your time. Okay, that'll conclude the public hearings. We'll take the roll call. The four of us here. I'll accept a motion of approval of the agenda. So
I'll second that.
all in favor? Opposed, motion passed. Approval of the minutes from the prior meeting, I'll accept that. So George, second. All in favor? Aye. Motion passed. Action on public hearings. First one, table from November 21st, 2024 meeting. Location of parcel of land known as lot 2 and 3 of the Morris Lakeview subdivision, fire number W6537 Simonson Lane. Is there a motion on the floor?
Mr. Chairman, I'm gonna make a motion to deny that variance request.
Mr. Peterman is making a motion to deny. Is there a second?
I'll second that.
John or Jess?
I don't care.
John second. We won't take a vote yet. We'll listen to George's reasons for his motion to deny.
Unnecessary hardship is not present. The code requirements are not unnecessarily burdensome, will not prevent the owner from using the property for a permitted use. Because the landowner has reasonable use already, the cumulative impacts can be foreseen. A self-imposed hardship cannot be grounds for approval, and a loss of profit or inconvenience is not a hardship. The hardship is not due to unique features or limitations of the property and appear to be unique to the applicant because there are similar lots in the area. The code requirements are not unnecessarily burdensome and should be adhered to. It's a self-imposed hardship, and a loss of profit is not the hardship. The variance will not harm the public interest or neighboring land uses and damage the intent of the zoning code because an approval would set a precedent. This would make a bad situation worse. An increase in water runoff and erosion is anticipated. Harm to water quality is anticipated. The proposal appears to be for convenience to the landowner only, and an approval would undermine the code and harm the neighboring properties and public interest at large. Therefore, if this is denied, the following conditions should apply. The applicant shall remove the 12 by 12 addition that was constructed without permit by June 1st of 2025 and replace the elevated walkway that was approved under land use permit number 20-324. The non-conforming retaining wall that was recently constructed without permit shall be removed by June 1st, 2025, and the property regraded back to original elevation and reseeded to match existing. And the applicant will allow agents of Waushara County to access the property to ensure compliance with the terms of this decision, Waushara County codes, and the state and federal laws.
You've heard George's reasons for a denial. A yes vote will be to deny. I'll take a roll call vote. John Sharp? Yes. George Peterman?
Yes.
Jess Urban?
Yes.
And the chairman votes yes. 4-0 to deny the variance request. Our second hearing is John and Sherry Bell. The fire number Town of Dakota, W 8427 Clearwater Avenue. Do we have a motion on that? Motion approved by Mr. Shirk. Is there a second?
Second.
Jess seconds. Mr. Shirk, your reasons, please.
Unnecessary hardship is present, and the current code requirements would be unnecessarily burdensome and prevent the applicant from using the property for permitted use, because very few alternatives exist due to the narrowness of the lot. The impacts of construction are being minimized by mitigation. A minimal relaxation of the code is being granted. The circumstances are beyond the control of the applicant and are unique to the property, not the applicant. The lot predates zoning regulations and construction matches the lot and available area. The hardship or unreasonable burdensome limitations of setbacks is due to unique physical features or limitations of the property and not the circumstances of the applicant as follows. Very little buildable area exists. The lot is very narrow and overall lot size is small. The variance will not harm the public interest or neighboring land uses and damage the intent of the zoning code because this would make a bad situation much better. The proposed use will not harm the public, zoning code, or neighboring land uses if conditions are followed. A literal enforcement of the zoning code would be unnecessarily burdensome, and testimony in opposition has been considered and no valid reasons could be found to deny. Therefore, the request variance, if approved, the following conditions shall apply. The development must be in substantial compliance with the site plan and testimony provided at the public hearing. First floor elevation and filling and grading shall be done in accordance with the site plan and additional information provided at the public hearing. All other requirements setbacks must be complied with. All permits must be obtained, including land use, building, and sanitary reconnect. If system is being reused, which it will be. At the time of the building permit and land permit use, the applicant shall revise plans to incorporate gutters and downspouts on elevations of the home. Said downspouts must then be connected to a French drain system or other stormwater management system so as not to shed runoff onto adjacent properties. All code requirements must be complied with. It is the responsibility of the builder and landowner to protect the neighboring lots, lake, and roads during construction. Standard erosion controls must be in place prior to construction starting. Any future construction cannot occur without first obtaining a variance. The driveway shall meet all code specifications and shall provide suitable turnaround to prevent backing onto the road. The applicant will allow agents of the Waushara County access to the property to ensure compliance with the terms of this decision, Waushara County codes, and state and federal laws. The landowner is responsible for maintaining good visibility at the driveway entrance. The landowner is also responsible for determining lot lines and required setbacks, and the building shall not exceed a maximum of 35 feet.
Thank you, John. Any discussion? Take a roll call vote. George? Jess?
Yes.
John?
Yes.
Chairman votes yes, 4-0. What's that? Somewhere here I got something. Extensions,
We have none.
variances for next month?
Right now, we have one, Becky, two variances.
Minor changes,
None.
map interpretations.
None.
Okay, we already did the next month's hearings.
Yep.
We got the financial report. Any questions or comments from the board? Hearing none, I'll accept the motion to adjourn. So second,
Second.
all in favor?
Aye.
Thank you. Motion passed. Thank you, gentlemen, for being here. Thank you, Ruth, for being here.
Next month is Moosin and then that Shades.
Oh, yes.
That's what it is.
Did Shades get their plat in?
I don't know.
That's why.
I don't think so.
So we'll be here.
We might, yes, we're gonna be here definitely.